All right, government class, this is the last video in regards to some of the Supreme Court cases that we've been looking at and the amendments in the Constitution. In particular today we're going to be focusing on the 14th Amendment, and within that really Equal Protection Clause and in regards to discrimination and affirmative action. All right, and so really there's two kind of terms here we need to start out with, and that's the idea of the rational basis and strict scrutiny. And so what the Supreme Court does when they get cases that involve race or equal protection or anything like that is they look at the rational basis, or they use a strict scrutiny in regards to their decision. All right, so rational basis. So what rational basis would mean is there some compelling government reason or outcome that the government's trying to obtain by having this law passed? All right, so if there is some sort of proper purpose that the government is trying to enacting, then rational basis is used. Okay, and so usually when we talk about rational basis, we're talking about a lesser type of laws. Okay, we're not talking about race, we're not talking about religion, we're just talking about, okay, does the government have a compelling interest to have this in place? So we use a lower threshold for kind of acceptance of the law, and that's just a rational basis. Strict scrutiny, on the other hand, is a much more defined situation, and that usually then is based on race, sex, national origins, things of that nature, in which laws have been passed which are kind of targeting various groups. And so now there has to be strict scrutiny on this, that the Supreme Court has a very much a narrower, let's put it that way, a narrower determination of what is acceptable and what isn't. All right, and so as we kind of get into this a little bit, we need to kind of start with the first case that really kind of kicks us off here, and that will be the Plessy versus Ferguson case. All right, so the Plessy v. Ferguson case in 1896, as we look at segregation, kind of started the separate but equal policy in the United States. All right, in that case, the Supreme Court ruled that you may separate the races as long as you provide equal facilities, separate but equal. All right, so you could have separate rail cars, you could have separate schools, you could have separate anything, as long as you are providing equal facilities. And that was the governing ruling from 1896 all the way to 1954. And then the Supreme Court in 1954, in the case of Brown versus the Board of Education of Topeka, Kansas, stated that separate is inherently unequal. Anytime you take one person and you tell them you can't be with the other people, that is discriminatory, that is unequal. You regardless of the facility that that individual is going to, you created an unequal situation. And so the court in that case ruled that states must integrate schools with all deliberate speed. All right, so again, that case dealt primarily just with schools. But of course, from there, we start to see the kind of flood of decisions through the civil rights era of the 1950s, and we start to see busing and other things that also will be told that you can't separate, you can't discriminate or segregate any longer. Okay, and so the Brown case is a landmark case that kind of dealt with this issue of segregation. And so because we had decades upon decades and centuries of inequality in the United States, obviously going back to our inception as a country, all the way through the Civil War, then after the Civil War with Jim Crow in the South, and then racial segregations throughout, and even through the Civil Rights Movement. You know, we're talking about all this time where, you know, discrimination, prejudice, and such created an unequal playing field. The government began to create what we refer to as affirmative action programs. All right, affirmative action, positive actions by the government that were aimed at trying to create a more equal playing field and to help alleviate past wrongs. All right, so the idea being, okay, for a generation or two, we need to enact these type of programs to help minorities get more opportunities, and once they get more opportunities, that will begin to level the playing field, and we'll have a more equal society. That was the hope, that was the goal. All right, and so affirmative action programs began, you know, as early as the 1960s through the 70s, and we begin to see more of it into the 80s. And so, you know, as we kind of look through these cases, in the 1970s, 1973, Bakke versus the regents of the University of California. All right, and in that case, Bakke is really, he was a white individual who applied to go to the University of California and had been denied. Now, his GPA and his test scores and everything else were meeting the threshold to get in, but he was not being accepted. And what it appeared to him to be is that some minorities were being accepted who didn't quite meet the threshold he had. And so he felt that through affirmative action, what it was also creating is a term that we now use as reverse discrimination, that even though he was of the majority, a white male, that he was being discriminated against because of his white maleness, and therefore he should have equal protection under the 14th Amendment. And so eventually this case does go to the Supreme Court, and when it gets to the Supreme Court, the court kind of does a yes-no on this. They side for Bakke and say, yes, you are right, you were discriminated against and you should have been into the University of California, but colleges are okay to use race as one of the qualifying determinations in regards to their acceptance in admissions. All right, the idea being that we want to give opportunities for minorities who have not had opportunities in the past to go to college, to get degrees, and hopefully end the cycle of discrimination and prejudice and such that has occurred in our country. And so there was a compelling interest of the government to do that. And so the Bakke case was one of those that's kind of interesting because they did rule for him, but they also left the door open that, yes, you can use race as a determining factor here. All right. And so as we kind of move through the 80s and then into the 90s, the courts begin to change a little bit, and we have seen affirmative action in place in a number of ways. And so for many people, they thought, well, maybe we should see if we still need this programs or these programs. We start to see more and more cases, and we're going to stick to these cases involving college admissions, and in particular, the University of Michigan. There's two cases here in the same year. Gratz versus Bollinger and Grutter versus Bollinger. And again, it's the same court that's ruling on both these cases, but we see two different rulings here. All right, so in the first case, Gratz versus Bollinger, the University of Michigan was using in their undergraduate admissions kind of a point system. All right, and one of the factors in the point system was race and a couple other issues that help deal with minorities to help bring minorities into the University of Michigan. And Gratz was saying that, again, he was discriminated against because, again, he didn't get those points for being minority. And in this case, the Supreme Court said that, you know what, yeah, the University of Michigan did not meet the strict scrutiny threshold on this, and that their admissions policies need to be reworked, that they can still use race, but it can't be such a weighted system, all right, that it's got to be more equitable. That race can be a factor, but it can't be a large determining factor in regards to admissions, all right. Then you have the Grutter case, and the Grutter case, again, it's kind of centered around the same thing, but this time the court said, no, University of Michigan, you did it right this time. Your strict scrutiny is upheld, that you can use race, and you did use race in determining factors of who got in that program, but you did so in a way that meets the strict scrutiny threshold. And so, these are early 2000 cases in regards to, again, affirmative action and issues of prejudice and discrimination that we're still obviously dealing with to today. So, the 14th Amendment, equal protection under the law, usually a lot of times it's dealing with race or gender or many other kind of equitable issues that we've been talking about. So, all right. So I guess, hopefully you guys are healthy and doing well out there, and I look forward to seeing you soon.